Yes, Judge.
Good morning. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for June 22nd, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
In cause number 2023-0D01189, State of Texas versus Liliana Camacho. Announcement of council, please.
Eliana Elizalde for the state.
Regina Arditi for Lilian Camacho.
And Mr. Marufo, I think I asked you off the record, Ms. Camacho checked in. When did she check in?
Yesterday at 3:50, Judge.
Okay. I had her down as a no-show, but I guess she did call in. Is that right?
Correct, Judge.
Okay. And so I was discussing with counsel and Ms. Elizalde. I had seen that I didn't know if Mr. Vandenberg or you were going to be here today. But in any event, he signed off on these plea papers. I'm assuming, is that who you were dealing with, Mr. Arditi?
Yes. Originally, I had spoken with Ms. Elizalde, and that's where the recommendation had come out from. That she was.
Okay. And the recommendation was 15 days under 1244 A or B?
B, Your Honor.
Okay. So I received these plea papers either late yesterday, early morning today, and when I reviewed them, I immediately kicked them back, not thinking that that this was actually set today. So I'm glad you all are here because there's an error on the offense range of punishment, a discrepancy 1244A, 1244B. I'll take that as a typo. But in terms of the recommendation, which you reviewed this document with your client, correct, Mr. Diddy?
Yes, I did, but I had explained to her, Your Honor, that because she was going to be doing jail time, the probation would not apply to her.
But you do read this document as the court does, that it contains a $2,000 fully probated fine, 100 hours of community service, TAP, BHRTC, UABA, curfew, and no offensive contact with the complainant. And this is, what is this?
This is a drug charge, but there was another case, a misdemeanor case that that David was going to dismiss. And in the misdemeanor case was an assault case.
So you understood the terms of this plea to include the no offensive contact and BHRTC, is that right?
Well, no, what I assumed what's happening, and again, I will take full charge on that, because they were going to be dismissing the assault charges. And because she was going to be doing work release 15 days in jail, there was not going to be any probation or any other terms or conditions. So I thought that was just a mistake on David's part. And so I had explained to her.
And you didn't make the effort to correct the mistake. Instead, you just had your client sign that and explain something different than was represented in the plea papers. You do understand that this document, first of all, it's not enforceable. I don't know how in the world I would get an individual doing jail time to go to BHRTC, but it is stated, and it sounds to me now that I would have thought this was just a mistake in the sense that the state accidentally left the language there, but you're telling me that there was an assault case, so that it was intentional to leave a condition that included no offensive contact with her father? When you know that that is not enforceable when she's doing jail time?
Correct, and that's what I told her, that none of that, because she's doing jail time, that there's no probation, there's nothing else, and there's no community service, there's no fine, none of that would apply. And I said, probably a mistake on David's.
And you didn't correct the plea papers, right? You didn't scratch it out, call Mr. Vandenberg and say, hey, Mr. Vandenberg, this doesn't apply. Why is this in here, right?
No, I did not, Your Honor. I did not do that.
Okay, well, in any event, I sent them back. So we are not scheduling this for a plea just yet until the plea papers are corrected.
Okay.
So we keep our settings. That's the first issue. The first issue, however, brings up a very good point. You had made a request to appear remotely while your client would be appearing in person for a plea, which this court absolutely believes is an essential hearing. And
Okay.
as an essential hearing, I am not granting your request to appear remotely, and it is especially for exactly what has happened here today. What has happened here today and what you've explained to me today is that you've somehow consulted or advised your client in executing these plea papers. You made assumptions, and if your client had questions, they need to have direct communication with you, not you on Zoom. So that request, as an essential hearing, as a plea is denied. It will be an in-person proceeding, and it will be scheduled once I get plea papers that make sense.
Okay, Judge, as soon as I get the plea papers, I will have my client go over them and then I will send them back to the court.
Thank you very much. Was there anything else I need to know about this case? In terms of the work release, I don't have an issue with work release. She's been compliant with PR every other matter. Alrighty.
Nothing further from the state, Judge.
I have
Thank you.
nothing further, Judge.
Thank you. You're excused.
Thank you, Judge. Bye-bye.
Does anything else need to go on the record? I think I saw Mr. Valenzuela, Ms. King.
Yes, Judge.
Okay, let's go ahead.
Good morning, Judge.
Page 6, Judge,
Mhm.
in cause number 2021-0D00640 and 2021-0D00641, State of Texas versus Randy Alexander Martel and Christopher Rick Martel. Announcement of council, please.
Robert King for the state. Good morning, Your Honor. State is ready.
Felix Valenzuela, on behalf of both clients and standing in for Joe Spencer for his client. Your Honor, ready?
And for purposes of the record, good morning, counsel. For purposes of the record, the attorneys are appearing remotely, but we're waiving the defendant's appearance, Mr. Valenzuela.
That's correct, Your Honor, for both defendants.
Okay, so we're here for 2801 motions. Let me just check status with you all first, and I will have to ask because I actually was wondering about that trial setting. I asked because I thought I understood Mr. Spencer to say he may have some scheduling issues in another case, and I wanted to confirm that that wasn't going to be an issue here. I don't recall independently the timetable, but I thought I had some health concerns that I had not heard of before, so I just wanted to inquire about that as well. In any event, let's start with pretrial 2801s.
Your Honor,
I'm sorry, go ahead, Ms. King. Apologize.
I believe we have all the laps back from DPS as far as trace evidence, DNA. However, I did let Mr. Valenzuela know a couple of minutes ago that I will be making a copy on an actual CD of everything in the case, and I'll send a copy to, he should have it available by the end of today for him and for Mr. Spencer as well, to just make sure that we haven't missed anything and portal has everything up.
Okay, anything else, Ms. King?
No, Your Honor.
I do see we have Odyssey, so that's a nice thing. I do see some motions filed here. So Mr. Valenzuela, what do you have for the court?
So we have filed some 2001s, but I don't think we have anything that needs to be heard this far in advance. It'd be on the eve of trial, even after voir dire. And there is something I'd like to share with the court, but off of YouTube, if Ms. King consents, regarding Mr.
That's
Spencer.
fine.
Yes, absolutely, we can do that. Can we stay on the record though?